Of the 523 pirates tried in admiralty courts between 1716 and 1726, fewer than 40 were acquitted. That is a conviction rate of 92%. Modern criminal courts in democratic countries average around 67%. The best funded, most professional justice systems on earth convict people at 67%. The Admiralty Court in the golden age of piracy hit 92. And before you tell yourself that the gap just means the evidence was overwhelming, that every man who walked into those rooms was clearly and provably guilty of what he was charged with, I need you to sit with a different explanation. Because the evidence does not support that reading. What the evidence supports is something much simpler and much more disturbing. The court was not designed to determine guilt. It was designed to produce a specific number. And once you understand the architecture underneath the wigs and the formal Latin and the deliberate ceremony of it all, you will never think about piracy or about justice or about what the word trial actually means the same way again. Welcome to Dead Man's Shore. I'm Jack. This channel is about the real history of the most violent, most chaotic, and most deliberately misrepresented world that ever existed on this planet. We go behind the legend. We go behind the romanticized version. We find what was actually happening underneath the story everyone was told. If that sounds like your kind of channel, hit subscribe right now and turn on notifications. New episodes come out regularly, and this is exactly the kind of history you do not want to miss. Now, 1700. That is the year everything changed. Not because of a famous pirate, not because of a dramatic sea battle, not because some legendary ship went down in a storm and took the golden age with it.
1700 is the year the English Parliament passed the Act for the More Effectual Suppression of Piracy. And that act did something that had never been done before in the history of English law. It eliminated the basic architecture of common law for anyone accused of piracy. Not modified it, not limited it in specific circumstances. Eliminated it. For an entire category of defendant, the foundational legal protections that had been built and refined across 7 centuries of English legal tradition simply ceased to apply. Let me be precise about what was removed. Under English common law, if you were charged with a serious crime, you had the right to a jury of your peers. 12 people drawn from your community, not appointed by the government, not selected for their reliability as conviction machines, but ordinary people who understood the context you lived in, who could tell the difference between a man who chose violence and a man who had a musket pressed against the back of his neck. You had the right to call witnesses in your own defense, even witnesses who were far away. You had the right to have your case heard in England, under the full weight of the procedural protections the system had accumulated over centuries. The Act of 1700 took all of that away. Trials could now be held anywhere, not in England, not before English juries, in colonial ports across the Atlantic world. Cape Coast Castle on the West African coast, Nassau in the Bahamas, Port Royal in Jamaica, Bridgetown in Barbados. Ports where the men sitting in the galleries watching the proceedings were merchants who had lost cargo to pirates, or captains who had lost their ships, or men whose commercial livelihoods depended entirely on the sea lanes being cleared of the people currently standing in the dock. The audience had a financial interest in a particular verdict, and the audience got to watch the judges work. Those judges were not independent. They were naval officers and colonial officials appointed by the crown. Men whose careers were built on demonstrating loyalty to the same government that had decided piracy needed solving at scale. Some of them had personally commanded the vessels that captured the defendants they were now judging. Some of them stood to collect prize money if the defendants were convicted and their ships condemned as prizes. The incentive structure of the court pointed in one direction, and the court moved in that direction at 92% efficiency. There was no defense attorney in any meaningful sense. There was a reading of the charges. There was testimony, taken quickly and not always challenged with anything approaching rigor. And then there was a verdict, usually delivered on the same day the trial began, sometimes within hours of the charges being read. And forced crew members, men who had been seized off legitimate merchant ships at gunpoint and pressed into service under a pirate captain, were regularly convicted alongside the men who had chosen the life deliberately. The system was supposed to distinguish between them. In many cases, it tried. But it was not built to make that distinction carefully, not in one day, not at the pace that 272 defendants in a matter of weeks required. The machine was built to move, and things that slow down movement tend to get moved past. 92% does not happen by accident. That number is not the byproduct of overwhelming evidence. It is the fingerprint of design. But before we get into the mechanics of how a trial actually ran, I want to tell you about two men. Because statistics are statistics. Statistics do not make you understand what a system costs. What it costs requires names. William Kidd will cost you something, if you let yourself look at what actually happened to him. Captain William Kidd was not, when the story begins, a man at obvious risk of ending up in a cage at the mouth of the Thames. He was prosperous. He was respected. He had a house in New York, a wife, a successful career as a privateer captain, and connections to some of the most powerful men in the English political world. He was the kind of captain that governments hire when they want something done properly at sea. In 1695, that reputation made him attractive to a group of Whig lords who had a problem to solve. The problem was real. Pirates and French privateers had been devastating the East India trade for years, attacking merchant vessels in the Red Sea and along the Malabar coast, threatening the trading rights that made the whole enterprise enormously profitable. The English East India Company was losing ships. The Mughal emperor was furious. Something had to be done, and doing it through a privately funded privateer was cleaner than doing it through official naval channels. The men who approached Kidd were not minor figures. They included Richard Coote, the Earl of Bellamont, who was about to take up the post of governor of Massachusetts and New York. Other Whig lords whose names moved through Parliament like currency. They structured the arrangement with the King's awareness and provided Kidd with a privateer commission dated December of 1695, along with a second commission authorizing him specifically to pursue pirates. Kidd fitted out a ship called the Adventure Galley, 287 tons, 34 guns, purpose-built for extended operations in distant waters. He signed on a crew of around 150 men and sailed for the Indian Ocean in the spring of 1696. And then the voyage became a disaster. Not all at once, and not through any single catastrophic decision, but through the slow accumulation of bad luck and bad circumstances that turns a promising enterprise into a catastrophe by degrees. Disease took men. Months went by without prizes. The crew Kidd had assembled was expecting to be rich within a year, and a year passed, and they were not. In October of 1697, a confrontation on deck with his ship's gunner, a man named William Moore, ended when Kidd struck him with an iron-hooped bucket. Moore died the next day. It was not a planned killing.
It was the violent end of a shouted argument on a ship under enormous tension for months. But it was a death, and the man responsible was the captain, and that would come back for everything. In early 1698, Kidd took the prize that changed the trajectory of his life. The Quita Merchant was a large ship, heavily laden, carrying silk, muslin, sugar, iron, and saltpeter. She was sailing under a French pass, which established her as a legitimate target under the terms of his commission. He seized her, took the pass as evidence of her legal status, and understood that he had done exactly what he had been sent to do. He did not yet know what was happening in England. The political winds had shifted while he was at sea. The Tory opposition was hammering the Whig lords who had funded the voyage, using it as evidence of recklessness and impropriety. Powerful men who find themselves holding an embarrassing document have options that ordinary men do not. His backers began quietly creating distance between themselves and the enterprise they had designed and funded. And the French passes that Kidd had taken from his prizes, the documents that could prove his prizes were legitimately taken, disappeared from the official record. Not lost at sea, not destroyed, filed in a London archive, placed in a folder, and left there. Kidd came back to the Caribbean in 1699 with a growing understanding that something had gone badly wrong. He made contact with Bellamont, his own backer, now governor of New York and Massachusetts. Bellamont's letters were reassuring. "Come in, bring the documents, we can sort this out." Kidd sailed to Boston, believing that a man with a legal commission and evidence of legitimate prizes could walk into a British colonial capital and be heard. Bellamont had him arrested within days of his arrival. He was sent to London in chains. He spent more than a year in Newgate prison before his trial. The charges were murder for the death of William Moore and 5 counts of piracy. His defense rested on the French passes and his privateer commission. The passes were not produced. The judges were informed they could not be found. The commission was presented and considered insufficient. The men who had designed and funded the voyage were not called to testify. They had other business. He was convicted on all 6 counts. He was hanged at Execution Dock in Wapping on May the 23rd, 1701. The rope broke on the first attempt. The crowd found this entertaining. He was hanged a second time and died. His body was then taken to Tilbury Point at the mouth of the Thames, coated in tar, placed in an iron cage custom fitted to his dimensions, and mounted on a gibbet where it would remain, visible to every ship entering or leaving the Thames for the next 3 years. In 1910, a researcher working in the Public Record Office found both French passes in an archive folder where they had been sitting since 1701. They were genuine. They established that at least some of Kidd's prizes, including the Quita Merchant, had been legitimately taken under the terms of his commission. Nobody issued a correction. Nobody acknowledged that a man had been convicted and displayed in a cage at the mouth of the Thames, in part because evidence proving his legitimacy had been filed away in a folder. The system had already gotten everything it needed from William Kidd 200 years earlier. There was nothing left to extract. Now hold that story in your mind and place another one next to it. Because Kidd's case was one man destroyed by a specific political situation. What happened at Cape Coast Castle in 1722 was something different in character. Not one man destroyed by politics. 272 men processed by a machine. Bartholomew Roberts was the most successful pirate of the Golden Age. Not the most famous, not the most mythologized, but by the actual count of ships taken and the geographic scope of his operations, there was no one who came close. Over roughly 3 years, working across the Atlantic from Newfoundland to Brazil to the West African coast, Roberts took somewhere between 400 and 470 ships. That number is not an exaggeration. It comes from logs, from testimony, from the insurance records of the period. In February of 1722, HMS Swallow caught Roberts's fleet off the West African coast near Cape Lopez. Roberts was killed early in the fighting, shot in the throat by grape shot while standing on the quarterdeck of his ship in crimson waistcoat and breeches, the gold chains he always wore to battle still around his neck. He had left instructions that his body go into the sea rather than be taken by the Navy. His crew honored that wish. He went into the Atlantic water dressed the way he had chosen to live. 272 of his men were taken to Cape Coast Castle. The Admiralty Court convened and processed all of them in a matter of weeks. For context on that speed, a modern American murder trial with a single defendant routinely runs for weeks or months. The Cape Coast proceedings ran multiple defendants simultaneously, comparing testimony across groups, moving through the list as the schedule allowed. The entire proceeding for all 272 men took less time than a modern traffic case. 52 men were sentenced to death and hanged, most at the fort itself.
Their bodies gibbeted along the coast, where passing ships could see them at intervals like warning signs mounted along the water. 70 men were sentenced to 7 years of labor for the Royal African Company, working the logistics of the slave trade along the West African coast. The mortality rate in that assignment was, by surviving evidence, comparable to the mortality rate among the enslaved people being transported through the same system. 17 men were imprisoned. The remainder, those who could demonstrate forced service credibly enough to satisfy the court's limited patience with the question, were eventually released, though several died in confinement before any determination was reached. The question of who had chosen the pirate life and who had been dragged into it was not thoroughly investigated. It could not be thoroughly investigated in the time available. Men who had been taken off merchant ships at gunpoint, told to navigate or go over the side, who had spent months looking for an opportunity to escape that never came, stood in that dock alongside men who had sought out Roberts's crew deliberately and signed his articles with full understanding. The court was supposed to distinguish between those two categories. In many cases, it tried. But the system was built for speed, not for the kind of painstaking reconstruction of individual circumstance that genuine distinction required. The machine was running. So let me walk you through the actual mechanics of a trial under the Act of 1700. Not the theory, the procedure. The trial was held in whatever space was large enough at whichever colonial port the prisoners had been brought to. At Cape Coast Castle, that meant the hall of the fort. At Nassau, the governor's building. At Port Royal, one of several suitable structures. The judges sat at a table, between 5 and 7 of them, all appointed by the Crown, all owing their positions to the same government that had decided piracy needed solving at scale. There was no defense attorney in any professional sense. A defendant could speak in his own defense and call witnesses if they happened to be present, but he had to manage this himself, in a legal environment he probably did not understand well, in front of judges working through a list. The rules of evidence were permissive by modern standards. A confession was admissible, regardless of the conditions under which it had been obtained. Testimony from fellow pirates was admissible, even when those pirates had obvious reasons to redirect blame. Crew lists found aboard the captured vessel were admissible, and a man's name on a crew list was treated as significant evidence of willing participation, regardless of how it had come to be there.
Merchants and captains who had personally suffered losses sat in the galleries watching the proceedings with a clear financial interest in the verdict. The treatment of forced crew members was the single most consequential flaw in the system. Courts were supposed to investigate whether a man had joined voluntarily. In practice, the investigation was often cursory. There are records of men testifying that they had been taken off legitimate ships at gunpoint, given no meaningful choice, looking for an opportunity to escape for months, and being convicted anyway, because they could not produce corroborating witnesses, because their account conflicted with someone else's, or because the court was moving through the list and the distinction was taking longer than the schedule permitted. The average trial for a single defendant took 1 day. Many took considerably less. After the verdict, the process continued. A man condemned for piracy was hanged, and then his body was prepared. It was coated in tar. Coal tar applied thickly over the skin and clothing,
enough to seal the surface against rain and wind, and the biological processes that would otherwise reduce the remains to an unrecognizable state within weeks. The purpose of the tar was functional. They needed the body to last. Then a blacksmith built a gibbet cage. The cage was custom-made. A blacksmith took measurements from the condemned man and constructed an iron frame sized specifically to hold him. Bars running the length of the torso, hoops around the chest and hips and limbs. A lattice of iron that would maintain the human shape as everything inside it slowly ceased to be human. The cage kept the bones from separating. It preserved the silhouette. It maintained the recognizable outline of a man long after the man himself was gone. The cage was mounted at a location chosen for maximum visibility to maritime traffic. Harbor entrances, river mouths, prominent headlands. The gibbet at Tilbury Point, where Kidd's body hung for 3 years, stood at the mouth of the Thames, the passage that every ship entering or leaving the greatest port in the world had to navigate. Every sailor on every vessel making that passage looked at it. They were meant to look at it. There was a culture around the gibbets that does not appear in official records. It lived in the taverns and the ship's messes and the dockside conversations of the maritime world. Sailors knew the names. When a new body went up at a prominent point, the news traveled through every port in the Atlantic, and men talked about who it was and what he had done, and how long the body had been up there, and how long it was likely to last. The gibbets were landmarks in the literal sense, navigation points. A sailor entering the Thames in 1703 could orient himself partly by the cages he passed. A well-tarred body in a well-made cage, mounted in a location with moderate wind and not too much direct weather, could remain recognizable as a human body for 3 years. Some lasted longer. The record holders, cages in protected positions, occasionally retarred by the authorities, remained visible for decades. Reduced eventually to a skeleton held together by iron, the bones bleaching to white, the cage oxidizing to deep rust, the whole structure creaking on anchor points as the wind came off the water. 3 years is a long time for a message to run. So let me tell you what the court was actually doing. Not what the Act of 1700 described as its purpose, what was actually happening. The Admiralty Court was a production, a performance with a predetermined conclusion, designed not to determine guilt, but to generate a specific kind of visible consequence at a scale and a pace and in locations that would reach the maximum number of people who needed to receive it. The message was this: the sea is not free. It was never free. The men who thought it was free were wrong, and the cost of being wrong about that is hanging in a cage at the mouth of the river where you cannot miss it. Not for a week,
not until everyone has had a chance to see it once. For 3 years. For decades. Until the iron rusts and the bones fall apart, and the next cage goes up. The theater of the trial was essential to this purpose. The judges in their formal dress, the reading of the charges, the Latin, the ceremony of the verdict. These were not purely functional elements. They were the frame around the painting. They made what happened in that room look like justice. A man condemned by that ceremony, in that room, with that level of visible formality, could be placed in a cage at a harbor entrance without anyone asking uncomfortable questions about whether the process had been thorough. Because the process looked thorough. It had the costumes and the language and the gravity of fairness, even when the architecture underneath was designed to produce a result rather than discover one. Here is the thing about theater. The audience does not always know it is in a theater. The sailors who passed Kidd's gibbet at Tilbury Point were not thinking about French passes hidden 2 miles away in a London archive. They were not thinking about Whig lords who had funded the voyage and quietly distanced themselves when the political winds shifted. They were thinking about the figure in the cage, about what category of choice had put him there, and about what they would have to do or not do to avoid a similar ending. That was the intended effect. The gibbet was not a statement about William Kidd. It was a statement about the category William Kidd represented. Men who operate outside the law, who sail beyond the reach of the merchants and the navies and the trading companies that have organized the Atlantic world to benefit themselves. That category ends at Tilbury Point. The specific details of how any individual man arrived at the cage were not part of the message. The message required the body and the location. It did not require accuracy. This is why the 1910 discovery of the French passes produced no reaction. A researcher found the documents. They were authenticated. They established that Kidd had legal authority for at least some of the actions for which he had been convicted and displayed. The finding was noted, filed again, and the world moved on. By 1910, Kidd had been dead for 209 years. His name was a synonym for piracy. The legend did not need a correction. The system had extracted everything it needed from William Kidd in the first 3 years after his death, during the time his body hung at the mouth of the Thames. When the papers were filed again, the record closed. Nothing changed. That is perhaps the most honest moment in the entire story, because it reveals what the system always knew about itself. The court was a machine for producing messages. The gallows was the press. The gibbet was the distribution point. And the message kept running for years, for decades, long after the court had adjourned and the last argument about evidence had been forgotten. Let me give you the image I keep returning to. It is the spring of 1704. A merchant vessel is making its way up the Thames toward London. The crew is tired after a long voyage, thinking about pay and shore leave and the small rewards that come after months at sea. The river is crowded, the greatest port in the world running at full capacity on a clear morning. And there is a lot to see on the passage upriver. At Tilbury Point, they see the cage. They know who it is. The story of William Kidd has been running through the maritime world for 3 years, through every port and tavern and ship's mess in the Atlantic. They know the name. They know the broad shape of the story. Privateer gone wrong, tried in London, convicted on 6 charges, hanged at Wapping, displayed at the mouth of the river. What they do not know, what no one in 1704 knows, is that the French passes are sitting in a London archive less than 2 miles away, filed in a folder, waiting, proving that at least some of what Kidd did was authorized by the same crown that condemned him. They do not know that his backers are alive and comfortable and have suffered no consequences. They do not know that the commission that was supposed to protect him was dismissed in a proceeding that lasted less than a day. They see the cage. They understand the message. The ship moves on upriver. The cage falls behind them. And somewhere in the part of the mind that makes calculations about risk and survival and the cost of the wrong choice, the message has arrived exactly where it was aimed. That is what the court was for. That is what the 92% was for. Not truth, not justice, not the careful determination of individual guilt. That single moment, multiplied across every ship entering every harbor in the Atlantic world,
Repeated for every year, a body remained in a cage at a headland, delivering the same message to every sailor who passed. The message did not require the court to keep meeting. The message kept running on its own. The 523 men tried in those courts between 1716 and 1726 were not all the same. Some had signed pirate articles with clear eyes, embracing a life that offered wealth and a kind of violent freedom the legitimate maritime world simply could not provide, accepting the risks that came with that choice. Some had been taken off merchant vessels at musket point, told to navigate or go over the side, and spent months looking for an opportunity to escape that never came. Some were in the vast, complicated middle ground between those poles, men whose choices had been shaped by poverty and the brutal economics of maritime labor, who had weighed a legal sailor's wage against a pirate crew's share of the prizes and made the calculation that most people with limited options make when the alternatives are laid out plainly. The court did not investigate those distinctions carefully. The court produced a 92% conviction rate. If you have stayed with me this far, I want to ask you something specific. Think about the men at Cape Coast Castle in 1722, the ones who had been taken off merchant ships at gunpoint and ended up sentenced to labor on slave trade vessels. They were not pirates by any reasonable definition. They were victims of piracy who got processed through a court built for efficiency rather than accuracy. And they had to stand in that dock and explain the difference between themselves and the men who had chosen the life, in a system that had one day to care about the difference. In the comments below, tell me this. If you had been a sailor in 1720, taken off your ship by force, kept for 8 months, and then stood in that dock alongside the men who took you, what would you have said? What words exist for making that distinction clear in a room that was not built to hear it? The men who were actually in that situation had to answer that question in real time, in front of judges working through a list. Most of them didn't have a good answer. Not because they were guilty, because in a system designed to produce a specific result, a good answer is almost never enough. I'm Jack. This is Dead Man's Shore. Subscribe if you haven't already, because there is a great deal more of this kind of history ahead. History that does not resolve cleanly into a story of good men stopping bad men and justice being served. History that looks directly at how the systems governing the most dangerous world on Earth actually operated, underneath the ceremony and the wigs and the formal language of the law. The court is adjourned. The cage is still up.